Fewer than 7 in 100 Americans who hold a credit card know that their account agreement contains a clause removing their right to sue the company in court. The Consumer Financial Protection Bureau measured this. The Bureau asked cardholders directly whether their agreement included such a clause. 75% did not know whether it did or not. Of those who believed they knew, more than half were wrong about whether their own agreement actually contained it. And among the consumers whose agreements did contain the clause, fewer than 7% understood that it meant they could not take their credit card company to court. The clause is legal. It is standard. It is in the agreement the humans signed. Warren will come back to one detail about this clause that most humans find unexpected. It concerns what happened when the federal agency responsible for protecting consumers tried to change it. The clause is called a pre-dispute arbitration clause. It appears in the terms of service for bank accounts, credit cards, prepaid cards, private student loans, and mobile phone contracts. When a human agrees to these terms, which typically happens at account opening, on a screen, in a block of text below the portion most humans read, they are simultaneously agreeing that any future dispute with the company will be handled through arbitration, not through the court system. Arbitration is a private dispute resolution process. It is run by private companies, most commonly the American Arbitration Association, or JAMS. The arbitrator is typically a former judge or attorney selected from a pool. The proceedings are confidential. The decision cannot be appealed in most circumstances, and in 9 out of 10 cases, the clause also contains a class action waiver. The class action waiver means the human has agreed, at the same time, not to join with other humans in filing a collective lawsuit against the company. The Consumer Financial Protection Bureau studied 6 consumer financial markets between 2010 and 2015. The findings were consistent across every market. 53% of credit card agreements, covering as many as 80 million Americans, include these clauses. 92% of prepaid card agreements, 99% of payday loan agreements in California and Texas, 86% of the largest private student loan agreements. Warren notes the consistency. Here is what the clause removes in practice. A financial institution charges a consumer $35 incorrectly. This charge appears across several million accounts in the same billing cycle. No individual consumer is going to pay a $200 arbitration filing fee to recover $35. No attorney is going to take a case where $35 is the amount in controversy. The consumer absorbs the charge. Multiply this across enough accounts, and the arbitration clause becomes a mechanism that permits the extraction of small amounts from large numbers of people who have no practical means of challenging it. Class action lawsuits were built specifically for this category of harm. They allow many consumers who suffered the same small injury to combine their claims, share legal costs, and create a case large enough for an attorney to represent. The Consumer Financial Protection Bureau examined class action settlements in consumer financial markets over a 5-year period. At least 160 million class members were eligible for relief across those settlements. The total value returned to consumers was approximately $2.7 billion. The average individual payout was $18. $18 does not sound significant. $2.7 billion extracted from 160 million consumers who each had no practical individual remedy, that is, the structure the class action waiver eliminates. Warren has noted this. The Consumer Financial Protection Bureau spent 5 years studying this problem. The Bureau released its final study in March 2015. The study documented with specificity how arbitration clauses limited consumer access to relief. It documented the class action waiver problem. It documented consumer awareness, or the absence of it. 2 more years passed. In July 2017, the Bureau issued a final rule. The rule did not ban arbitration. It preserved a consumer's right to bring an individual arbitration case. It prohibited one specific thing, the class action waiver. Companies could still require arbitration for individual disputes. They could not use the arbitration clause to block consumers from filing class actions in court. The rule was published on July 10, 2017. 31 days later, the House of Representatives voted to overturn it. 95 days after that, the Senate voted 51-50 to overturn it. Vice President Mike Pence cast the deciding vote. President Trump signed the resolution into law in November 2017. The rule that took 5 years to build survived 4 months. There is something else. The Congressional Review Act, the legislative tool used to overturn the rule, also permanently prohibits the Consumer Financial Protection Bureau from issuing any rule that is substantially similar. The Bureau cannot try again. Warren will return to what this means for the 80 million Americans currently covered by these clauses. The third point is the one that changes the structure permanently. Consider two entities currently in a dispute over a billing error. The first is a consumer who believes they were charged incorrectly. They are encountering the arbitration clause for the first time. They have no prior experience with the arbitration process. They do not know where to send their dispute, how long they have, or what the filing fee is. The second entity is a financial institution that helped design the arbitration clause in their agreement. The institution has participated in thousands of prior arbitration proceedings. It has a legal team, a compliance department, and a standing contract with the arbitration provider. It has pre-built responses to the most common consumer claim categories. The consumer is deciding whether to pursue the dispute. The institution has already calculated, statistically, what percentage of consumers in this situation will not. Warren has observed this arrangement. It was not accidental. The Consumer Financial Protection Bureau's study noted that arbitration clauses were deliberately written at a higher complexity and reading grade level than the rest of the agreements they appeared in. The complexity is a feature, not an oversight. And since November 2017, no federal rule can change this. The Congressional Review Act's permanent bar means the mechanism is, for the foreseeable future, protected from federal regulatory challenge. The structure is stable. The number Warren returns to is 7%. 7% of Americans covered by arbitration clauses in credit card agreements understand that those clauses removed their right to sue. 93% are operating under an agreement they did not know they had made. The companies know they made it. The companies designed it. The companies successfully defended it before the Supreme Court, which upheld class action waivers in arbitration agreements in a series of decisions between 2011 and 2018. The companies successfully lobbied for the elimination of the only federal rule that would have limited its scope. Warren is not describing wrongdoing. Warren is describing a legal structure. Every element of this structure, the clause, the waiver, the rule's elimination, the permanent legislative bar on reinstatement, is permitted, documented, and in most cases, irreversible after the fact. The human agreed to it. The human had the option to read the agreement before signing. Warren acknowledges that option was technically available. Warren also notes that in most cases, the agreement is presented as a non-negotiable condition of accessing a financial service the human requires to function in the American economy. A checking account, a credit card, a phone contract, these are not optional services. The structure was designed knowing this. One thing Warren noted during research, between 2010 and 2012, the period the Consumer Financial Protection Bureau studied, consumers filed approximately 300 arbitration cases per year in the credit card market. During that same period, the top 50 credit card companies sent a combined total of more than 8 billion monthly billing statements per year. 300 cases, 8 billion statements. Warren has reviewed the ratio. The clause is in the agreement. The agreement was written by lawyers retained by the financial institution. The clause removes a right, specifically, the right to join with other Americans in a collective legal action against the company. This removal is legal, standard, and has been embedded in most financial agreements for more than a decade. Warren observes one final detail. The Consumer Financial Protection Bureau is required by law to notify consumers of this clause when a company invokes it against them. The notification arrives after the dispute has already begun. The notification is legally compliant. The timing is something Warren has considered at length. My name is Warren. I watch humans earn six figures and wonder where it went. I never wonder, I watched.